The Court of Justice of the European Union is made up of two courts, the Court of Justice and the General Court. Created as the Court of First Instance, the Second Court of the European Union pursues several objectives. Today, we discuss this with its president, Mr. Marc van der Woude, who also explains why the member states decided to equip the Union's judicial system with the Second Court. President van der Woude, thank you for being with us today. In 1988, the member states decided to create the Court of First Instance, today the General Court. Why?
First, thank you for your invitation. Yes, it's a long story, the creation of the General Court. I think it should be seen in the context of the 80s and in particular in the context of the internal market project as promoted by President Delors. The industry contributed to that project, but it was also concerned by the degree, or say by the intensity of legal protection offered at that time by the Court of Justice. The fines went up in competition cases, there would be merger control, and all things which of course were not necessarily in favor of European industry. And they said, okay, we are happy to contribute to this project, but we would also like to have, say, in-depth judicial control. That was one of the elements. The second element was the evolution of the Strasbourg case law, saying that in matters which were quasi-criminal in nature, that there should be at least judicial protection in two levels, and not only one court but two courts. And then there was the phenomenon that the Court of Justice was overburdened. And there's often a relationship between the intensity of judicial control on the one hand and a court being overburdened on the other. So it was decided that in competition cases and other cases which related to human beings, i.e. staff cases, that those cases would be then transferred to the Court of First Instance at the time, with appeal of course before the Court of Justice.
The General Court is described as the court for direct actions. What does that mean?
It means that an individual, a company, or sometimes even a member state, which has a problem with EU decision, a regulation, or sometimes even a directive, that those entities can challenge that act directly before the General Court and not before a national court. When you go to a national court, there may be an EU component in that litigation when the national court refers a question to the Court of Justice. And that's what we call indirect actions, because you go first to the national court and indirectly the Court of Justice is being called upon. Whereas in the case of direct actions, people go directly to the General Court, and if they're not happy with our decision, on appeal before the Court of Justice. So basically, the General Court is the administrative judge of the European Union. So if there's something wrong with the many bodies, entities and institutions in the Union, and people want to have legal protection, they can seek it before the General Court.
Thank you, President van der Woude, for these explanations.
Thank you.
See you in the next episode of Open Court.